Okay, so my topic today is the IT due diligence on medical investment. So first, let me have several minutes to introduce a very specific and unique pilot zone in China. So this is Hainan Free Trade Port, Boao-Lecheng International Medical Tourism Pilot Zone. And this special zone is localized in Boao, Hainan, China. So Boao, you also know Boao is also famous for its forum, Boao Asia Forum. And it is also, held today, this year, even due to the pandemic. This picture shows the area of our Lecheng pilot zone. So you can see it is localized, in the Qionghai city, and with the plant area up to 20 square kilometers. And it is very near to the highway and international and the airport, only 10 minutes by car. And there are already we have already established more than 16 medical institutions and hospitals in our new pilot zone. And you see this beautiful river, we call the Wanquan River. It is a very famous river in China, especially famous in a very lovely song. So our pilot zone is also famous for our provincial policies approved by our state council. So the state council, provide 9 provincial policies to Lecheng pilot zone. It can be summarized as 4 priorities. So first priority is medical entry. Is focused on medical entry. It means that special permissions in importing medical technology, medical experts, and medical device and medicines, drugs to the pilot zone. The second priority is specific medical approved right empowered to the zone, enabling foreign capitals to invest the hospitals and medical institutions. The third and the fourth priorities is focused on the international academic and healthcare exchange and medical research. For example, the medical research, even the clinical trial and clinical applications on stem cell and even the immunity cells. Okay. So I will talk more about the first try policy. In our pilot zone, both device and medicines that was approved in foreign countries, but not approved in China, can be applied in this specific zone in China. So this policy we call try first, even without approved in China. So this policy, bring bless for patients of the Lecheng. This picture shows some companies and medical device and also medicines that has been incorporated to our Lecheng pilot zone. And you can also see that for this capsules made by Pfizer, German, it was approved in America and Europe in 2005, but not approved in China until now. But our pilot zone, incorporated this new drug in 2019, so that Chinese people can apply to such special drug only in Lecheng in China. So now we have incorporated more than 30 drugs and more than 100 medical devices into our broad Lecheng pilot zone, so that the Chinese people can use the latest medical device and medicines together with other global people. And we also shortened the approval date from 20 even longer days to 3 to 7 days. And this is also a very attractive policies. We call it, it is known as the real-world data study, real-world data evidence. So those real-world data can apply to support the approval of this drug in Chinese FDA. We call it NMPA. So now the first real-world study, real-world data was used in pilot zone since 2019. And you see this specific drug, it is a eye clinic drug. This drug is from the Igen, and this drug was approved in China in last year, completely based on the real-world study data in Lecheng. So it is a very exciting news that not only Chinese people can apply this new medical device in Lecheng, but also the real-world study data can also help to such medical device to be approved in China and used in all regions in China. And we also set up a global latest device and drug expansion. And this is, we showed the many drugs and medicals that was not approved in China, so that many people, even visit our zone, can see this latest outcome in the global pharmaceutical and medical device giant. Actually, we have a new building to set up and opened this year for the special foreign medical device and drug. And then I also following to my second part of my presentation. So it's we call it the IPDD medical device, intellectual property due diligence on medical investment. So I will talk about 5 key points of the IPDD due diligence during our medical device investment. Actually, I helped many global clients and Chinese clients to do their technical transfer or technical license during their investment and merger and acquisition. So, the next 5 key points is based on my actual experience, and hope that I can share with you, and not only the Chinese pharmaceutical companies, also the European pharmaceutical companies and medical device companies. So first, I will have a very brief introduction and use the patent right as an example. So when you apply a patent and own a patent, you should make sure 5 points of your patent. First, what is the right of your patent? Second, what is the power of your patent? And third, how to commercialize your patent? And fourth, when you want to practice your product or your techniques in the market, you also should know how whether you can freedom to operate your technique. So after you have a basic line of your patent and your technique, I will also came to discuss the 5 key points during the medical investment. So first, during your due diligence in your medical investment, the first point is review of IP ownership. Because misunderstanding IP ownership may result in many serious results. For example, the inability to transfer your real right, and maybe your IP value is lower than your expectation, and maybe the finally failure of your M&A. So the typical defects of IP ownership might be summarized as 3 types. The first, the target company does not possess the IP right. The second, the IP right even possessed by the target company, but this right is restricted, is limited. And the third is that the right might be jointly owned also by other companies. You know, the first is that maybe the target company want to cooperate or you want to merge is not the real owner of the IP right. So there are some small key points. I'll just give some examples for your consideration. For example, maybe the employee enjoys the patent right. You know, in American, in United States, employee is their patentee, is their patent applicant of the patent right, and the company is always the assignee. So the employee is the assigner, and the company always act as the assignee, but only assignee, not the patent right holder. So you need to check the description in the patent publication, and you need also to check their employment contract. And another example is that technical partners also have the patent right. For example, it may be a cooperative development contract, you know, between your target company and its technology partners, but based on their contract, maybe the partner possesses the patent right, not the target company you want to cooperate or you want to M&A. Another thing is that the third party owns the patent right. So please make sure carefully review the patent license contract, just if and to make sure that whether those patents can be licensed or can be transferred from the third party if the third party only owned this core technique. The second typical defects of ownership is that IP right is limited. For example, is limited is restriction by license out. So the patent is owned by target company, but the target company has already licensed those patents to other licensee, to other licensee. Yeah. For example, there are many. This shows the common types of right limitations during the M&A. For example, the license type, the license area, and domain, and of the sub-license, the right to sub-license, of the ability to grant the sub-license, or even the agreement to modification of the license agreement. And also the duration, the time length of the license agreement and the license right. Also, patent right might be limited by the line and mortgage. For example, your right is lined to the company, to the bank, and the bank must also may have other rights, may have its own right on your IP. Another thing is that if your patented technology is supported by government funding, it might require other specific evaluations, for example, national security control, or the foreign license and transfers evaluation and approval. The third example is that this IP right is jointly owned by other companies. So regarding to those issues, the general principle is contact priority. But you need to clarify that whether the IP right, transfer of IP right is required by all the agreement by the all co-owners, because in different countries it might have different rules and different laws. For example, in United States, any co-owner has the right to license and sell this IP right to a third party or donate it to the public without the consent of other owners. The second point of IP due diligence is you need to pay attention to your region and temporal review of your IP right. For example, the region review of your IP right means that the IP rights are only valid in its own country and region and has no extraterritorial effect. The temporal review means that different rights, even different IP rights have different durations, and also different countries have different patent term extension strategies. For example, the patent linkage might be would be discussed by the next speaker, and also in American you may heard the PTE and the PTA and the patent dance, and in Europe you may heard the SPC for the drug patent. In China, we also have patent linkage and patent term extension in our new Chinese patent law, and will be effected in the coming June. And the third point is, please make sure to review the scope of your IP. So the examine whether the scope can meet the purpose of the merger and whether it can be effectively practiced by the acquiring party. So, for example, there is the key points that several notes when you review your protective scope of your IP. For example, whether the scope of your claims of the patent is too narrow so that it cannot be protect your core technique very well, whether the competitors can easily design around their patent and modify their product to avoid the infringement. And then whether your key point, your key technology is really covered by your scope of your claims, and whether your scope is stable when challenged by other petitioners, challenged by the competitors, and then whether the action of patent infringement is easily to be detected. For example, for some method claim, it is very hard to detect it in the pharmaceutical industries. For example, we cannot, visit their plant, visit their industries to check their production line, preparation lines. The point is that your patent claim should target on infringing subject, infringing product, and infringing evidence. So our suggestion is when you request your patent attorney to draft your patent at the very beginning, just to think from the infringer, just to think of after the patent is granted and how you practice your patent or commercialize your patent. And the fourth point is, to review the IP dispute of your target company. For example, there might be the infringement by third-party IP right. So, so your target companies might infringe other parties' IP right. So you need to review the litigations that your target companies is involved, and also to identify the potential risk. You need also not only pay attention to the pending case, but also to the terminated case, the closed case, to determine whether the relevant litigations still exist to determine the degree of your liabilities. And you need also to pay attention to the potential infringing issues, because in American, patent infringement might begin 6 years after their alleged infringement. And then, and also, the FTO freedom to operate analysis is also necessary to key product and your method. And this picture shows the key point for the third party infringe your target company. So this is the issue that is always ignored during the due diligence, because it might be hard. It's also hard to detect, to study, to search such infringement. Maybe you can review the past allegation by the target company to check whether the target company has claimed that their IP right was infringed previously. You may also review whether there are any competitors or third parties to challenge your target company's IP right. And you can also conduct the EOU search and analysis. The fifth point is review of the relevance and integrity of your IP right. The IP relevance review means that IP right is not an individual right. There might be many IP rights in your target companies. For example, we have patent pools. We have including basic patent and improved patent. This patent might within the target companies, and this patent pool might also exist among the enterprises. The competitors might rely on the association, to stop the merge and acquisitions, because the competitors also might own other partial IP rights in your patent pools. And we also suggest you to pay attention to the IP integrity review, whether the target IP is fully covered the core technology, as I mentioned